Okay, welcome to Professional Responsibility Unit / Week 5. We're going to be going through fees, safe holding of property, and also a part of a rule that allows you to, under certain circumstances in the contemplation of litigation, to forward court costs and other types of costs concerning the litigation. All right, let's start. All right, so lawyer fees, both the ABA and California, and we'll look at the California rule, it's very similar to the ABA rule, has a rule concerning the fees that a lawyer can charge a client. And the client fees in the ABA, the first and foremost thing you need to know, as you see in Section A, is that the lawyer fee shall not be unreasonable. So the fee has to be a reasonable fee. And how do you determine whether the fee is reasonable? Well, they give you a group of 8 factors, which are not all-inclusive, but should be considered when charging a client a fee. One is the time, of course, and labor required. So that's the effort. The novelty and difficulty of the questions, how sophisticated is the law that's required, or the process and procedures that you need to go through, and the skill requisite to perform the legal service properly. I mean, can any lawyer do this? Does it take a specialist to do this? How long have you specialized in this? Go to 2, the likelihood, if apparent to the client, that the acceptance of particular employment will preclude other employment by the lawyer. If you can't do anything else except work on this case, well, that's going to impact the bottom line. So this is really an opportunity cost type consideration. 3, the fee customarily charged in the locality for similar legal services. So, for example, in Manhattan and New York City, similar legal services to something in, say, Des Moines, Iowa, which is a much smaller metropolitan area and much cheaper, less expensive, more affordable area. Well, those two, you wouldn't be charging the same amount of legal services for similar legal services, okay? So that's one thing that you'll take into account. That doesn't mean a lawyer in Des Moines can't charge those services, but it's something you charge that fee. It's something you have to look into. The amount involved in the results obtained. So what is this about? Is this a $5,000 settlement? Is this a $50,000, $500,000, $5 million settlement? Is this a transaction that's worth, $10,000 to each side, or is it a $1 billion transaction? And also, the results obtained. That's oftentimes you play that into the contingency. If you're gonna charge a contingent fee. Time limitations imposed by the client or by the circumstances. If this is something that can be done pretty much at your leisure or in a reasonable time frame, and time is not of the essence, well, maybe you don't get to charge as much. But if you need to drop everything for the client and do it right now, well, that should be taken into account, because that also goes into number 2, opportunity costs. If you have to drop everything for a client, maybe you should charge that client more. The nature and length of the professional relationship with the client. This goes into, what has the client been paying you before for similar legal services. 7, the experience, reputation, and ability of the lawyer or lawyers performing the services. So experience and ability, of course, are important, and the more experience and the higher your ability, the more you should get paid. But also look at the reputation. The reputation is just not how good of a lawyer are you, but what do the judges think of that lawyer? When a judge sees that lawyer come before his or her court, are they glad to see that attorney, or they know that attorney is going to be a nightmare, will perform bias, and things like that? And then you have 8, whether the fee is fixed or contingent. So you need to take that into account. A fixed fee may be an hourly fixed fee or a fee based upon the transaction. So, for example, say I'll write you a will for $250, or I will work on your divorce for $250 an hour. Or in a personal injury, I get 33% of the net recovery from your injury. Those are examples of fees or fixed fees and contingent fees. So let's look at comment 1 here. So it says the factors specified in 1 through 8, what we just went over, are not all inclusive, and nor should each factor be relevant in each instance. Each case is different, but these are a good starting point to determine whether the fees are reasonable. Okay, and remember, it is the reasonableness of a fee when it comes to the ABA rules. Also, if you look and go back, it says there must be reasonable expenses too. So you can't charge an unreasonable fee, and that's paying for the lawyer's services, but there's also other expenses that go into a representation of a client. So for example, it says reasonable expenses a lawyer may seek reimbursement for include the cost of services performed in-house. So if you're working for the client and you are copying things, that is a reasonable cost. Or for other expenses incurred in-house, such as telephone charges, okay, either by charging a reasonable amount to which the client has agreed in advance or by charging an amount that reasonably reflects the cost incurred by the lawyer. So the expenses have to be reasonable that you charge the client, not just the fees. Okay, B, this has to do with the scope of the communication of the scope and the fees and the expenses. So it says the scope of the representation and the basis or rate of the fee and expenses for which the client will be responsible shall be communicated to the client. So the client has to know what it's going to cost them, and preferably in writing. But it doesn't have to be in writing. But you'll see for a contingent fee must be in writing, and that we'll get to that rule soon. Okay, so preferably in writing before or within a reasonable time after commencing the representation. So, for example, the best thing to do is right up front communicate your fee schedule and the expenses that the client is going to be going to have to reimburse you for. Okay, and you should do it at the very start of the relationship with the client. Okay, or soon thereafter. Don't wait till the case is over and then say, "Here's my bill." That will not be that may not be considered reasonable when it comes to if there is contention between you and the client concerning what it is the client should pay. Okay, so except when the lawyer will charge a regularly represented client on the same basis or rate. If you have a regular relationship with a client, you may already have a structure in a pay structure, a fee structure, an expense structure in place. And therefore, that would be reasonable to follow that. However, if it's a new client, and even if it is another client that you have a history with, that's a regular client, you really want to communicate, hey, remember, these are our fees, these are our expenses, you still continue to agree upon them. So when things come up at the end and you hand in the bill, you have less to argue about. Okay, any changes in the basis or rate of the fee or expenses shall also be communicated to the client. So if you have a regular client or if it's a new client and something comes up that's going to cost more, or your expenses have gone up and you need to charge the client more, you need to communicate that to them. So comment 2 kind of breaks it down between regularly represented clients and a new client. So when regularly represented clients you have a history with, they ordinarily will have evolved an understanding concerning the basis or rate of the fee. There's generally not a lot of issue with them. However, if you're going to change things, you must communicate with them, and you also should continue to update them and say, hey, this is our fee structure. Do you still agree to this? If it's in writing, well, then you have a contract behind you, and it should be in writing. However, with a new client, you should an understanding of the fee and expenses must be promptly established. Like I said, don't wait till the case is over and say, well, here's my bill, and the clients go, well, we never talked about fees or expenses, and you're going to say, oh, these are reasonable. Well, the client's probably not going to accept that, so you want to do that up front. So generally, it's desirable to furnish the client with at least a simple memorandum or a copy of a lawyer's customary fee arrangements that states that the general nature of the legal service to be provided, the basis rate, and all that stuff. A written statement concerning the terms of the engagement reduces the possibility of misunderstanding. So remember, fee structures and fee agreements don't have to be in writing. It's preferably in writing, but put them in writing. Okay, here's the contingent fee, and this has to be in writing. Okay? A fee may be contingent on the outcome of the matter for which the service is rendered, except in a matter in which a contingent fee is prohibited by paragraph D or other law. So there are some instances where representation of a client in certain matters, you cannot charge a contingent fee. So a contingent fee agreement shall be in writing, signed by the client, okay, so, and shall state the method by which the fee is to be determined. Okay, including the percentage or percentages that shall accrue to the lawyer in the event of settlement, trial, or appeal, litigation, and other expenses to be deducted from the recovery, and whether such expenses are to be deducted before or after the contingent fee is calculated. Okay, so you have to have a lot of, you have to provide a lot of information as to how your fee is going to be calculated when it comes to contingent fee, and it has to be in writing. Okay, and signed by the client. So the agreement must clearly notify the client of any expenses for which the client will be liable, whether or not the client is the prevailing party. Upon conclusion of a contingent fee matter, the lawyer shall provide the client with a written statement stating the outcome of the matter and, if there is a recovery, showing the remittance to the client and the method of its determination. So just generally, for those of you who may not understand what a contingent fee is, for example, if you have a client who is suing somebody because they've been injured, the normal, traditional definition of a contingent fee is that the attorney would get a certain percentage of the net recovery of that injury if indeed your client wins. So for example, usually it's a 33% type structure for personal injury. So if your client was awarded, say, $150,000, but it cost $50,000 to put on the case, you'd take $100,000, and if you had agreed and with the client and notified the client that certain expenses were going to be reduced, you'd take that $150,000, you'd get rid of the $50,000, so the net award would be $100,000, and as the attorney, you would get 33% of that, so you would get $33,000 or thereabouts. So that's the normal contingency in the personal injury or torts world. However, there's also other types of contingent fees based upon the outcome of a claim or a transaction, and your book goes through a couple of them. So pay attention to those. For comment 3 for contingent fees, it says, like any other fees, they are subject to reasonableness standard of paragraph A. Remember, the fees and expenses have to be reasonable under the ABA. In determining whether a particular contingent fee is reasonable or whether it is reasonable to charge any form of contingent fee, a lawyer must consider the factors that are relevant under the circumstances. Okay? Now, applicable law may impose limitation on contingent fees. So, for example, in the example I gave you concerning the 33% that the attorney can take, well, suppose the attorney wants to take 50% and the client's willing actually to agree to it. Well, there are certain states where it doesn't, where the percentage that a lawyer can take is max. There's a ceiling on that percentage. Some jurisdictions it's 33%. Some jurisdictions it allows up to 40%. Some jurisdictions stratify things based upon how far in the litigation things will go. Okay, so you just can't agree to anything in a contingent fee because sometimes they are capped. The percentage that a lawyer can take is capped. Okay, so that's applicable law may impose limitations on contingent fees, such as a ceiling on the percentage allowable. That's what we just talked about. Or may require a lawyer or to offer clients an alternative basis for the fee. One of the things when you talk about contingent fees, you might want to talk to you should talk to your client, and there's a formal opinion about this that was issued by the ABA concerning the reasonableness of fees. You should talk to them about the contingent fees, the good and bad, and any other fees that may be applicable, or other fee type that may be applicable, and talk to them about the good and bad, such as, so if the client doesn't have any money and they really can't pay you, a contingent fee for personal injury may be the only thing that's viable there, or else you really can't take the case. Well, what if the client has some money and the option is they could pay you on an hourly Well, maybe that'd be better for the client. So you need to advise and talk to the client about fee structures, especially if it's a contingent fee. There might be a better fee or a better fee structure available that the client would be able to afford. Okay, but the main point is to communicate with your client when it comes to these contingent fees, how it's going to be calculated and the expenses that the client is going to be responsible for. Okay, D. Okay, as you notice, in C it said at the very first it said is prohibited by paragraph D. So here's D. A lawyer shall not enter into an arrangement for charge or collect any fee in a domestic relations matter, the payment or amount of which is contingent upon the securing of a divorce or upon the amount of alimony or support or property settlement in lieu thereof. Okay, so this basically says, hey, if you're handling a divorce, you can't say if I get the divorce for cause, you give me $25,000. If we have to go with an uncontested, then I only get 10. Okay, or alimony. Again, if I get you more alimony, you pay me more. You can't do that. Same thing with property settlement or child support. Anything with money involved, you can't base it upon that. Also, and I looked on the internet in different jurisdictions, and what they talk about. Well, what about child custody? Can you have a contingent fee when it concerns child custody? Meaning, okay, I'm representing the father, and if I get full-time custody for you, you pay me more than if I only get half custody, or if you don't get any custody at all. Most jurisdictions don't allow that either. Some jurisdictions say, well, there's no money involved in that, but it's still a domestic relations matter. Okay, and also no contingent fees for representing a defendant in a criminal case. Now, when it comes to D1, and maybe the comment, I don't remember what the comment says, but in D1, suppose someone has already secured alimony. However, the spouse who's supposed to pay the alimony hasn't been paying it. Well, then you can charge a contingent fee in order to get the alimony that's supposed to be paid. All right? So that's different than securing or initially securing the amount of alimony. This would be a case in where you were trying to get the alimony that should have been paid that was already secured, and therefore you're allowed to charge on a contingent basis concerning that. That would be the same thing with support. Or maybe a property settlement as well. If the court issued a property settlement order and the wife wasn't abiding by it, and you represented the husband, well, you may be able to you are able to charge a contingent fee to get the property from her that was originally secured in the original domestic relations matter. Here's E. A division of fee between lawyers who are not in the same firm may be made only if, okay, this is a division of fee between lawyers who are not in the same firm. So this doesn't apply to lawyers or division of fees in lawyers who are in the same firm. All right, this is not in the same firm. So if you see a fact pattern where it says lawyers who are in the same firm, it doesn't apply. 1.5e doesn't apply. Now, of course, the reasonableness of the fee applies. The rules about contingent fees, the rules about whether they should be in writing, and all that other stuff applies, but 1.5e doesn't apply. So this is about splitting of fees or division of fees between lawyers who are not in the same firm. The division is in proportion to the services performed by each lawyer, or each lawyer assumes joint responsibility for the representation. Okay, so that'll make it reasonable. The client agrees to the arrangement, including the share each lawyer will receive, and the agreement is confirmed in writing. So this has to be in writing, and the total fee is reasonable. Okay, so those are the rules. So if you see like a fact pattern where an attorney refers a case to another attorney, and that attorney ends up giving some fees that they receive to the attorney who made the referral, well, that is prohibited by this rule, because the division of fee has to be in proportion to the service performed, and a referral, as we remember back in 7.2, You cannot receive anything of value for a referral, and also a referral is not services performed. Okay? D. So paragraph D prohibits a lawyer from charging a contingent fee in a domestic relations matter when payment is contingent upon securing a divorce or upon the amount of alimony or support of property. Okay. This provision does not preclude a contract for contingent fee for legal representation in connection with the recovery of post-judgment balances due under support alimonies or other financial orders, because such contracts do not implicate the same policy concern. So basically, if the divorce is secured and the alimony is secured and the other spouse is not paying it, you can represent the spouse who's not being paid on a contingent fee basis, because this is a post-judgment of a domestic matter. Okay, so it's a post-judgment. Okay, this is something that the authors in the textbook pointed out. ABA Committee on Ethics and Professional Responsibility, its formal opinion 93.379. Now, these are highly persuasive documents, these formal opinions. What I've read and researched, they are not actually binding, but they are good guidance when determining certain issues, ethical issues under the ABA model rules. So this formal opinion 93.379 was cited in your book, and it refers to fees and reasonable fees. So it says, if billing is based upon time spent, a lawyer cannot bill for more than the actual time spent, except for rounding up to minimum billing increments. Okay? Now, if you did the reading, which I'm sure all of you did, it talked about billing in increments, 6-minute increments, 15-minute increments, 10-minute increments. Billing in time increments is essential, it says, and should not be objectionable unless unreasonably large. So if you're going to bill like in hour-long increments, and that's the minimum billing, and you do like a 2-minute phone call, and you charge the you charge your client an hour because that's the minimum that you'll bill in, well, that's unreasonably large. Okay, you can't charge just because, well, I only charge an hour increments, so a minute is an hour is a minute. That's unreasonably large. Okay, and also charging in increments is not per se unreasonable. Okay, it's part of the business. It's an accepted part of the business, and as they talked about it in the book, it helps to efficiently account for time. Okay, so that's part of the essentialness of the billing in increments. Billing in time increments should not be abused. Okay, so for example, I think this came from the book, billing 15 minutes apiece for 2 5-minute calls within the same 15-minute period. That would be an abuse. You're charging 30 minutes for a 10-minute call, 10 minutes worth of phone calls, and those 10 minutes were within the same 15-minute period. Okay? All right. A lawyer cannot bill more than the time spent, even if a task ordinarily would take longer, but was shortened because a similar job was recently done for another client. Or the same could be said, for example, if you have institutional knowledge and you know how to do things much more quickly than others, or if you set up a template for certain cases that you take, which really makes the process of going through what needs to be done for the client much more efficient, much more effective, and much more timely. Okay? You can't say, well, you know, other lawyers who aren't as good as me or don't have the same process as me or have never handled a case like this before, they're going to take a lot longer. So why can't I just charge them what those other lawyers would? Well, that's prohibited. You cannot charge, a lawyer cannot bill for more than the actual time spent, okay? Unless it's a rounding up in the minimum billing increments, and that roundup is not unreasonable. No billing one period of time to more than one client. So, for example, you can't be drafting up, you can't say, well, I was drafting a complaint for my one client, but I was thinking about the contract dispute of my other client, so I was double tasking or multitasking. Can't do it. No billing one period of time to more than one client. So this is the California rule concerning fees. So it's 4-200. One of the differences, or main differences that I see between the California rule is the word unconscionable. A member shall not enter an agreement for a charge or collect an illegal fee. Of course, you know, you can't say, you can't do something illegal or charge something that's illegal, okay? But we're mainly concerned with an unconscionable fee. Now remember, the ABA rule is unreasonable. California is unconscionable. What's the difference? Well, I'm not quite sure. Unconscionable means extremely unjust, grossly unfair, unusually harsh, and shocking to the conscience. So you know that in the contract world, where an unconscionable contract is shockingly unfair to one side, right? Well, what does unreasonable mean? Well, unreasonable means excessive or unwarranted or immoderate. Doesn't sound as bad as unconscionable. So is California saying, well, you can bill an unreasonable fee, but once it becomes extremely unjust and shocking to the conscience, that's where we put our foot down. I don't know. Why the word unconscionable is in here, I'm not sure. Okay. However, if you take a look at the rule, you see that a lot of the same factors are involved in determining whether there's unconscionability. So I would use and look to the ABA opinions and comments and things as persuasive guidance as to how to use this rule. Okay? I don't think California is saying, yes, you can charge unreasonable fees. I don't think that's what they're saying. So take a look through this, and there's also, there's not really much of a comment in your book about it, but it's pretty similar to the ABA rule. All right, now let's go on to, this is a portion of Rule 1.8. This has to do with financial assistance to a client. Okay, so this has to do with current clients and specific rules. This is 1.18. So it's a lawyer shall not provide financial assistance to a client in connection with pending or contemplated litigation, except that. Okay, so note this rule has to do with financial assistance in connection with pending or contemplated litigation. Now that means trial. Okay, going to court. Except that a lawyer may advance court costs and expenses of litigation, the repayment of which may be contingent on the outcome of the matter. So, for example, if you have, and this is very common when it comes to a personal injury case, the client will come in and they will have no money, okay? And the lawyer will take a look at the case and say, I think we can win, I think we have a settlement here. And what I will do is I will pay for all of the cost of the litigation and court costs. However, once we win, those court costs will be taken out of your award, deducted from that award, and that's how these costs will be paid based upon the award. Okay, so contingent on the outcome of the matter. The lawyer could also agree that if we lose, you don't have to pay anything. Okay, so we will eat those court costs and expenses if you don't lose. If you lose, we will take it out of the award. And then we will also, as you know, we will have a contingent fee here. We will also take a percentage for our fees from your award, from that net award. So that's how this normally happens. Okay, this facilitates people who don't have enough money to sue people who have wronged them. So it allows for the attorneys to pay the court costs and get repaid later. Now, in E2, it's a lawyer representing an indigent client may pay court costs and expenses of litigation on behalf of the client, and there's no need to have repayment. Okay. Also, if you notice in E1, it says repayment of which may be contingent on the outcome of the matter. It doesn't have to be. Okay, so the lawyer could say, I'm gonna advance you court costs, and at the end, you got to pay them back whether we win or lose. Okay, or they could say, if we lose, you don't have to pay them back. Number two, is there's no really talk about paying it back. The person's indigent, so the lawyer eats the costs. So note, and I said this earlier, Rule 1.8e applies only in a litigation context where litigation is pending or contemplated. Also, the exception only applies to court costs and expenses of litigation. All right, so comment 10 speaks about that. Lawyers may not subsidize lawsuits or administrative proceedings brought on behalf of their clients, including making or guaranteeing loans to their clients for living expenses. So that's not a court cost or a cost of litigation, because to do so would encourage clients to pursue lawsuits that might not otherwise be brought, and because such assistance gives lawyers too great a financial stake in the litigation. All right, so if you're paying for a client's apartment, well, that's pretty obvious. Well, that's not an expense or a cost of litigation. So what is? So let's go on. It says, these dangers do not warrant prohibition on a lawyer lending a client court cost and litigation expenses. And what are those litigation expenses? So including the expenses of a medical examination. So if your client gets hurt and goes to the emergency room and has a bunch of medical expenses, okay, that is not a medical expense when it comes to a litigation. Okay, that is not a litigation expense. Okay, that medical expense is because of the injury, and generally it's after the injury that they go and they meet with the lawyer and determine whether there's a case and whether they can sue. So the lawyer can't say, oh, I'll pay those past medical expenses. But what medical expenses can the lawyer pay? Well, medical expenses that concern the litigation. So they can take them to a specialist and say, Your Honor, I'm sorry, doctor, my client was in an injury. I want you to diagnose the results of that injury. Okay, that would be a litigation expense. Okay, also the cost of obtaining and presenting evidence. Suppose they also said to that doctor, hey doc, we want you to be an expert witness, okay, at the trial. So they're going to be obtaining and presenting expert evidence in that case, and they can pay the doctor to testify, okay, because the doctor's not going to do it for free. Okay, they'll pay him as an expert witness, so that's a cost of the litigation. Okay. All right, so let's move on from there. So that's 1.8e. Okay, now we go 4-10. I'm sorry, California rule for payment of personal or business expenses incurred by or for a client. It's a pretty similar rule. It says a person shall not directly or indirectly pay or agree to pay, guarantee, represent, or sanction a representation that the member or member's law firm will pay the personal or business expenses of a prospective or existing client. Okay, except that this rule shall not prohibit a member with the consent of the client from paying or agreeing to pay such expenses to third persons from funds collected or to be collected for the client as a result of the representation. So this is when you get an award and the client has to pay somebody. This is different than paying court cost. You'll see examples of that as we go through the course. After employment, from lending money to the client upon the client's promise of writing to repay. So if it's, you can give a loan, a lawyer can give a loan to a client after employment. I don't know if that's after the end of the representation, but you can get a loan as long as they promise to pay it back in writing. And then here's what's similar to ABA Rule 1.8e. From advancing the cost of prosecuting or defending a claim or action or otherwise protecting or promoting the client's interest, the repayment of which may be contingent on the outcome of the matter. Okay, such costs within the meaning of this paragraph shall be limited to all reasonable expenses of litigation or reasonable expenses in preparation for litigation or in providing any legal services to the client. So that A3 is similar to the rule, the ABA Rule 1.5. Okay, B, nothing in Rule 4-210 shall be deemed to limit the rules 3.300, 3.310, and 4.300. Those have to do when you are, those rules are prescribing entering into an adverse material or financial situation to the client. All right, safekeeping of property. This is ABA Rule 1.15. This is very important, and this gets a lot of attorneys in trouble. Basically, the key is you want to keep the client's property separate from your property. You want to keep the client's money separate from your money. If the client has property or securities or bonds or stocks, you want to make sure that they are separate from anything you have and that they are secured properly and separately. So let's read the rule. It says the lawyer shall hold property of clients or third persons that is in a lawyer's possession in connection with a representation separate from the lawyer's own property. Funds shall be kept in a separate account maintained in the state where the lawyer's office is situated or elsewhere with the consent of the client or third person. Okay, so that, we're talking about money here. So it should be in a separate account. Okay, other property shall be identified as such and appropriately safeguarded. So that's stock, bonds, securities. Complete records of such account funds and other property shall be kept by the lawyer and shall be preserved for a period of, and they suggest 5 years, jurisdictions differ, after termination of the representation. So even after, if you pay all the money out to the client that's in their fund, that has been awarded to them, or upfront fees that you did not spend, even after everything's said and done, you still need to keep a record of it for a certain period of time. A lawyer may deposit the lawyer's own funds in a client trust account for the sole purpose of paying bank services on that account, but only in an amount necessary for that purpose. Okay, so this is really not doing anything but paying costs of an account. So if there's service charges on a trust account where you are holding multiple clients' money, you as an attorney can put money in there to pay for those costs. A lawyer shall deposit into a client trust account legal fees and expenses that have been paid in advance to be withdrawn by the lawyer only as fees are earned or expenses are incurred. So if your client says, here's $5,000 up front, you draw down on that based upon the hourly fee that you're charging me. What you need to do is you need to put that all in that account, and you can only draw down on it based upon the work you do. Okay? And remember, if you end your relationship with the client either during the representation or after it, you must make sure that the client gets these fees, unspent fees or deposits, back. D. Upon receiving funds or other property in which a client or third person has an interest, a lawyer shall promptly notify the client or third person. So, for example, if you represented a client in a personal injury case and the client won, and you finally receive the check for the award, well, you have to promptly notify the client, hey, the check is here. And you need to place those funds into a separate account to be dispersed to the client. And it says a lawyer shall promptly notify the client or third person. So you should notify them as soon as possible. If you're too busy and you don't have time to, that's tough. You need to notify them promptly as soon as possible. Okay, so except as stated in this rule or otherwise permitted by law or by agreement with the client, a lawyer shall promptly deliver to the client or third person any funds or other property that the client or third person is entitled to receive, and upon request by the client or third person shall promptly render a full accounting regarding such property. So promptly plays pretty big in this rule. So if you receive the funds and you know that they are the property of the client, you need to distribute those funds to the client promptly. Again, if you're too busy, one of the discussion questions talks about a woman who was in trial for a month. She waited a month. Well, that is a violation of this rule. You have to give them the property promptly. E. When in the course of representation a lawyer is in possession of property in which two or more persons, one of whom may be the lawyer, claim interest, the property shall be kept separate by the lawyer until the dispute is resolved. The lawyer shall promptly distribute all portions of the property as to which the interests are not in dispute. So an example here is, and in your readings, well, suppose a client has won $100,000 and you have a contingent fee with them, but the client is claiming that the contingent fee is too high, and you say the contingent fee was 33%, and the client's saying it's 25%. Now, it was supposed to be in writing, of course, because it's a contingent fee, but this is just an example. Well, you have to disperse from that $100,000 the money that is going to the client. Okay, so that's, for example, you know that the client is going to get at least $67,000, 2/3. So they have to get that. You have to disperse that. But you're saying you're supposed to get $33,000 for the fee, and the client is saying, no, you're only supposed to get $25,000 for the fee. So the best thing for you to do is to take that $33,000, or at least the $25,000, and put that in a separate account and wait until the dispute is resolved. You don't go and spend that money with the intention of, well, I'll spend it now and then I can reimburse it, because you may not have it when you need to reimburse it. So you need to separately put it away until the dispute is resolved. Okay, comment 1. A lawyer should hold property of others with the care required of a professional fiduciary. Securities should be kept in a safe deposit box, except when some other form of safekeeping is warranted by special circumstance. Securities or bonds, things like that. All property that is the property of clients or third persons, including prospective clients, must be kept separate from the lawyer's business and personal property, and, if monies, in one or more trust accounts. Separate trust accounts may be warranted when administering estate monies or acting in similar fiduciary capacities. A lawyer should maintain on a current basis books and records in accordance with generally accepted accounting practice and comply with any record-keeping rules established by law or court order. In your reading, the book talks about the commingling of multiple clients' monies in a trust account, and says, well, that is okay to do that as long as you keep track of each individual client's money in that trust fund, in that trust account. And you should put it, it's okay to put it in that type of trust account with multiple clients if you're not holding the money for a long time, if it's a small amount of money. However, if a client has a lot of money in which you'll be holding, you're supposed to put it in a separate account. Okay, so the readings give a good explanation and good examples of when to do it, and I found it very informative because I never really dealt with any of these accounts. The firms I dealt with always did that, and the administrative personnel always did that. California Rule 4-100, preserving identity of funds and property of a client. So this is the California rule. All funds received or held for the benefit of clients by a member of a law firm, including advances for costs and expenses, shall be deposited in one or more identifiable bank accounts labeled trust account, client's funds account. So California has their own rules that are similar. It says at the end, it says, no funds belonging to the member of the law firm shall be deposited therein or otherwise commingled therein. So again, you can't place the firm's money in with the client's money except under certain circumstances. Funds reasonably sufficient to pay bank charges, the same thing as the ABA rule. Here's two. In the case of funds belonging in part to a client and in part presently or potentially to the member of the law firm, the portion belonging to the member or law firm must be withdrawn at the earliest reasonable time after the member's interest in that portion becomes fixed. Okay, so that's basically saying, look, if you get a big settlement check for one of your clients and you put it into the client's trust fund, as soon as you know what portion of that money belongs to you based on the contingent fee basis, if you entered into that with your client, then you need to remove that money from the client's account and put it into your account. Okay, because if the money belongs to you, you cannot commingle it with the client. All right. Rule 4, a member shall promptly notify the client of the client's funds, securities, and other properties. Okay, so again, promptly identify and label securities, so they have to make sure that they keep track of them and provide good safekeeping. They suggest a safe deposit box as well, same as the ABA. Maintain complete records. same as the ABA. Promptly pay or deliver as requested by the clients any funds, securities, or other properties in the possession of the member which the client is entitled to receive. So that's pretty much the same rule. And it says the Board of Governors of the State Bar shall have the authority to formulate and adopt standards as to what records shall be maintained. Well, in the ABA rules, it talked about generally accounting practices or generally acceptable accounting practices. Here, the State Bar has basically said, look, we want you to formulate and adopt standards as to what records shall be maintained. So that's a little bit different, but it's pretty much the same rule as the ABA. Okay, so that is now the end of Unit 5, Week 1 lecture video. And remember, that is to supplement your reading. I actually found the reading in Chapter 5 very enjoyable, very straightforward, and very clear. I wasn't confused by much, which is always good. Hopefully you had the same experience. Okay, God bless, and see you in class.